Law on Banking and Financial Institutions, November 18, 1999. Chapter 1, Banking and Financial Intermediation. Article 1. Banks are legal entities licensed to carry out banking operations as their regular business. Article 2. Banking operations include 1. Credit operations for valuable consideration, including leasing. Guarantees and commitments under signature. 2. The collection of non-earmarked deposits from the public. 3. The provision of means of payment to customers and the processing of said means of payment in national currency or foreign exchange. Any entity carrying out even one of these three types of activities shall be considered de facto to be engaged in banking. An entity carrying out only one of these three basic activities, or only one component of each of these three basic activities, shall be known as a specialized bank. Article 3. Banks may also, for their customers or on their own behalf, perform or carry out 1. All the financial operations referred to in Article 4 below, except insurance services, which are the subject of a specific legislation. 2. Foreign exchange operations. 3. Money market intermediation, and all operations in negotiable claims on said market. 4. Transactions in derivatives. 5. Spot or forward dealing in precious metals, raw materials and commodities, and 6. Other services related to their core activities. Subject to the agreement of the supervisory authority. Article 4. Banks as defined above may, on their own behalf and for their customers either directly or indirectly by participating in one or more specialized institutions, carry out securities transactions which constitute financial intermediation, such as 1. Taking deposits for the purpose of subscribing or purchasing securities, pursuant to instructions received from individual customers or from open-end investment companies. 2. Subscribing in and trading securities. 3. Custody of securities. 4. Individual or collective management of securities. 5. Underwriting of securities upon their issuance. 6. Financial engineering. 7. Trading in derivatives, and 8. All manner of securities transactions on their own behalf, in their capacity as commercial companies and in compliance with the laws and regulations in force. Article 5. Other specialized financial institutions may also carry out the same securities transactions for their customers. Article 6. The National Bank of Cambodia has the power to license and supervise the specialized financial institutions in accordance with the provisions of Article 7. Paragraphs 4 and 11, and Article 33 of Law NS/RKM/0196/27 of January 26, 1996 on the organization and functioning of the National Bank of Cambodia. However, securities transactions, whether carried out by the banks and by the specialized financial institutions, shall also be subject to the supervision of a special commission, which shall ensure that savings invested in securities are protected through compliance with securities issuance conditions and with securities disclosure requirements. The composition and functioning of this commission shall be determined by the laws and regulations governing the financial market. Article 7. Owing to the risks that may result from a combination of securities activities within banks or within specialized financial institutions, such as the receipt of earmarked deposits and the custody and the management of securities portfolios, the supervisory authorities of the banking system and of the financial system, acting in concert either at the time of initial licensing or by regulation, shall establish rules for regulating combination of such securities activities. Article 8. The operations related to the banking business referred to in Article 3 paragraphs 2, 3, 4 and 5 of this law, and carried out for customers by entities other than banks, shall comply with the rules established by the supervisory authority. Chapter 2, Scope. Article 9. 1. The banking and financial institutions defined in Chapter 1, and hereinafter referred to as covered entities, shall be subject to the provisions of this law. 2. No person other than a covered entity may carry out banking operations on a regular basis. 3. No person other than a covered entity may make use of a business name, corporate name, advertising or, in general, any expression implying that it is an institution authorized to carry out an activity subject to authorization in accordance with the provisions of this law. Article 10. Covered entities shall comply either with the provisions of ordinary commercial law or with the provisions of the special legislation applicable to non-commercial companies, as well as with the provisions of this law. In case of conflict, this law shall prevail. Chapter 3, Legal form of covered entities. Article 11. A covered entity shall be incorporated either as a public company under commercial law or as a cooperative or a mutual non-commercial society subject to special statute. Cooperatives or mutual societies shall belong to a common federative body called a central body. Central bodies shall be responsible for ensuring cohesion among the entities affiliated with their network as well as the smooth functioning thereof. To this end, they shall take all necessary measures, in particular to safeguard the liquidity and solvency of each of these institutions and of the network as a whole. The central bodies themselves are considered as covered entities. Article 12. A covered entity may be locally incorporated in Cambodia or be a branch of a foreign bank. Article 13. With prior approval of the supervisory authority, a foreign bank may open an information, liaison or representative office in the Kingdom of Cambodia, which office shall not be entitled to carry out banking operations or financial intermediation and canvassing operations. Such establishments may be locally incorporated or be a simple entity, a delegate person, or an office, and shall be so entered in the trade registry. Such offices may use the business name of the foreign bank they represent. An authorization is given for a period of 2 years, which may be renewed once only. Chapter 4, Licensing of covered entities. Article 14. Before starting business, covered entities must obtain a license from the supervisory authority. Before issuing a license, the supervisory authority shall ensure 1. The qualifications of the shareholders and the accuracy of their reported financial position. 2. The ability of the principal shareholders to fulfill, jointly and severally, their obligation to strengthen the bank's own funds if required to do so in accordance with the provisions of Article 27 of this law. 3. The adequacy of human, technical, and financial resources for the planned activities. The supervisory authority shall be aware of the reciprocity offered by other countries when the shareholders of a locally incorporated bank or the head offices of branches of foreign banks are from said countries. Article 15. The supervisory authority shall reach a decision within 6 months of receiving the application together with all relevant documents. Applicants shall be notified of any refusal of authorization. The supervisory authority shall maintain a current list of licensed institutions, which shall be published in the Bulletin of the National Bank of Cambodia and in the Official Gazette of the Kingdom of Cambodia. Chapter 5, Minimum Capital, Solvency. Article 16. 1. Before obtaining a license, a covered entity that is locally incorporated as a company or a non-commercial entity, whatever its legal form, Must have fully paid up initial capital at least equal to a sum fixed by the supervisory authority. 2. Before obtaining a license. A branch of a foreign bank must have a fully paid-up capital endowment at least equal to the minimum capital of a covered entity locally incorporated as a company. 3. The minimum capital shall be fixed by a regulation issued by the National Bank of Cambodia. A portion of the minimum capital equal to a percentage prescribed by a regulation issued by the National Bank of Cambodia shall be permanently deposited with the National Bank of Cambodia as a guarantee deposit. The minimum capital of commercial banks shall amount at least to Rial 50 billion. Said amount has been determined on the basis of SDR equals Rial 5,616. The guarantee deposit maintained with the National Bank of Cambodia shall amount at least to 5% of the minimum capital. 4. A covered entity that is either locally incorporated or operating as a branch of a foreign bank must at all times be able to prove that its assets minus related potential losses and intangibles exceed its liabilities to third parties by an amount at least equal to the minimum capital. Article 17. Covered entities must also observe a solvency ratio, the level of which shall be fixed by the supervisory authority in compliance with international standards. The ratio shall be calculated as a proportion of the covered entity's net worth in relation to its risks.